Okay, welcome back everybody. This is part 2 of the Vocational Science Freedom online law class for June 2021. This class will be covering the redemption of your estate and the process by which the Vocational Science Freedom status docs are used in the real world after you get them filed and recorded. So we left off talking about binding arbitration, finished that up, and the understanding that binding arbitration predates Roman civil law and is therefore an older and higher authority. And now let's get into the aspects of what a court is and what you have to bring to a court. And as I said before, this was all covered very extensively in the totality of law class and the ins and outs of court class, which was the March and April classes of this year. So I'm not going to go through this ad nauseum as I did in those classes, but I figured it's just a good refresher to double check and go over again. Let's pull up the handout for that, which is the number 5, facts, evidence, and law. Basically what I did here for everyone, because this is 16 pages, there's 3 main things that you have to have in every court case. And it's the facts, which is the who, what, when, where, and how you felt, but not the why. Why you did something or why somebody else did something would be a conclusion as to one's state of mind. Now, not to say that in a court case you don't ultimately put that forward, but that's usually an aspect of, did they have motive to do what they did? When you're dealing with the inferior court system, this system of human trafficking that's running everything through probate and administering all of our estates through probate, the why becomes blatantly obvious. It's not something that you put into a fact. Facts are just who, what, when, where. Then you have your evidence, and your evidence is proving the facts. A fact would be that such and such a state was registered with the state of Michigan at such and such a date, and the evidence of that would be the birth certificate registration and the date that it was registered. And things like that are through and through the status doc set as far as when these various different things happened, and that then goes to show that this is what they're doing. And then lastly is the law. And in a court of record, you decree your own law. You say, this is the law I'm standing upon for this reason or that reason, and you decree the law of the case. And I'll show you later today in Drew's filings that he did for Colorado what he did in the law of the case and what he did in his court of record suit against the inferior court system. And just to make a note here about when you're suing the inferior court systems, what the attorneys will say or what the judges will say, they'll say, oh, we have immunity. We're immune from suit because we have sovereign immunity. Well, no, you don't. Because these private for-profit courts, which all have their own Dun and Bradstreet numbers, which is something else I'll show later today as well, a screenshot directly from Dun and Bradstreet that will show you that these courts are private, is that when a state enters into commerce regarding something, they waive their sovereign immunity. There's a few court cases, which I'm going to get from another gentleman friend of mine who does the same kind of work, but he does it much more in a fashion of putting them to task under their own rules. He is very, very good at running over the corporate state through using the Roman civil law system. I tend not to go that direction because I realize that we're not bound by it anyway, and we have a far better system under the common law that should be used and should be understood by everyone, that not only is it available, but it works just fine, and it's much easier because you basically retain all power in a court of record common law procedure instead of going in there in a equity / chancery position and having the judge decide what the law is. Because basically that's what they're doing. I mean, all of these judges are basically legislating law from the bench, which is clearly not allowed in the separation of powers clauses in both the state and federal constitutions. But you end up contracting yourself into that situation through licenses, registration of things, registration of your property, pledging your property and agreeing to be bound by Roman civil law, statutes, acts, ordinances, and municipal codes. You got to know what law you're using and why. That'll be explained when I go over Drew's suit about how you decree the law. But in the handout, what I did was I just made sure that the definitions of each of these words directly from Bouvier's Law Dictionary. And the long title of that law dictionary is A Law Dictionary Adapted to the Constitution and Laws of the United States of America and of the several states of the American Union, with references to the civil, meaning Roman civil, and other systems of foreign law by John Bouvier. Even the title of this dictionary teaches you that Roman civil law is foreign to us. Always has been, always will be. But you can make the mistake of contracting yourself into it. But that's what the status doc set does. It removes you from all contracts that you would have had with the corporate state under their system. All at one time. Wipes them out. Gets rid of them. As far as facts, evidence, and law are concerned, like I said, what I did was I made sure that I put the definitions of these three things, all the definitions from Bouvier's regarding these three definitions in here, which I highly suggest that everybody takes time to read. I'm not going to read all the way through it. I want to spend the vast majority of the time today going through how to do the process, not going through the little finer points of these definitions. But you should know what they are, and the definition of law was something I completely covered in the totality of law class. I explained how each of one of these various different laws and different origins of law and the different principal classes of law and different systems of law, how they overlap. And I did so by basically making different color-coded circles and putting circles over circles to show where these different types of law overlap. When I did it, I realized that I don't think there's anybody that's ever done that before in like a full picture to classify these things from a standpoint of being able to look at it as a picture, not just reading these definitions and trying to keep them straight in your head. But when I created the picture with the circles, it was even a great help to me to realize where these things do overlap and how they overlap. Our focus is always going to be at common law because, as it says here, when considered in relation to its origin, origin of law. Okay. There's only two origins of law, people. It's either statute law or it's common law. That's it. Those are the only two origins of law. When you know that and you understand that the foundational documents are common law, the Magna Carta is common law, the Northwest Ordinance is common law, the Declaration of Independence is common law, you realize that the law created by the people, decreed by the people, or decreed by the sovereignty, is common law. Just like the law decreed by the kings in England was also an aspect of common law, some of which we have adopted here and do still hold. Things like the Magna Carta, where after the Magna Carta was signed in 1215, every king after King John confirmed the Magna Carta through what was called the Carfamara Cartarum, or the confirming charter, where each king said, yep, the Magna Carta is the common law, and we're gonna stick to it. That's how we have it here. That's how it came to us, was through what I just said. Everybody should read all the way through this. Yes, it is 16 pages, but it's not horrible. And to understand the major differences between common law and Roman civil law. Like I said, common law is that which derives its force and authority from the universal consent and immemorial practice of the people. So from time immemorial, it's the practice of the people is the common law, is the best way to think about it and to stand on it. So the judge says, well, what gives you authority? Well, from time immemorial, the practice of the people, Your Honor. I'm one of the people. That's pretty much all the explanation you need to give him or her. If they don't get it, well, we'll get into what happens then through writs of error and holding the judge in contempt and so on and so forth. We'll get into that later today. As far as this is concerned, understand that that's the basis of the common law. Now we can get down to what a court of record is. And court of record is handout number 6. Courts and courts of record. What is a court? So a court is the person in suit of the sovereign, the place where the sovereign sojourns with his regal routine, wherever that may be. If you are on the side of the road talking to a cop Are you in court? The answer is yes, because he's going to be running his inferior court at the same time that you're going to be running your superior court. But guess what? It starts at the side of the road. It doesn't start when you actually get into a courtroom. It starts there, because he thinks he's acting with the sovereign authority of the state, and you are acting with the sovereign authority of the people. Now, he's wrong and you're correct, because he's too dumb to understand that if he's enforcing commercial law, that he doesn't have any sovereign immunity at all. So that's what a court is. It's you and your suit. The word suit used to be pronounced suite. They would have an E at the end. And the suite of the sovereign, were all of the people that followed around the sovereign to remember what happened in the sovereign's court from day-to-day happenings. But now, a suit is now considered a bunch of 8.5 by 11 sheets of paper. And that's what you put your suit into and onto. There's one other thing I should say here about that, is that when you write down something, technically it is a dead form of law. It's not spoken law, because spoken, and again, you can look at the definition of law and see that there's written and there's spoken. Spoken law is always, always, always higher than written law. So when the sovereign states something, or you state something in court, you can end up negating all of your paperwork, because if what you say in court contradicts what your paperwork says, then you've just basically thrown all your paperwork into the garbage, and it's now only what you say. What I suggest to people always is that when you go to court and you have your court of record open, you only answer the questions that you wish to answer. And if you don't wish to answer a question, or if it seems like it's a trick question, you simply say to the magistrate, you say, well, I didn't come prepared to answer that question today. I'll prepare a response in writing to you and file it into the court record later. Something like that. So you're not ever getting into a situation where the magistrate has been sneaky, basically, and removed your power, or altered your status, or put you under his jurisdiction by some sort of verbal consent, is basically what ends up being the problem. Another definition of a court: an agency of the sovereign created by it, meaning you, directly or indirectly, under its authority, meaning under your sovereign authority, consisting of one or more officers. So the magistrate, he's one of your officers. If you have a special master, he's an officer. The clerk is one of your officers. You can have marshals be officers of your court to enforce the writs and decisions of the court. Established and maintained for the purpose of hearing and determining issues of law and fact regarding legal rights and alleged violations thereof, and of applying the sanctions of the law, authorized to exercise its powers in the course of law at times and places previously determined by lawful authority. That's out of Black's Law, 4th edition, and there's also a Texas appeals court case that also cited that as the definition of what a court is. Now, what's a court of record? A court of record is a judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it. Again, that's out of Black's Law 4th and a bunch of other court cases. So, what does that mean? It means that the magistrate has no power. They don't decide anything, because the tribunal is independent of that magistrate. And because the tribunal is independent of the magistrate, they don't determine anything, like I said. If the defendant files a motion in an attempt to move the court to, say, dismiss your case, in a proper court of record, what the magistrate has to do is the magistrate has to ask the plaintiff if it's okay if he grants that motion. And of course, if it's a motion to dismiss, obviously the plaintiff should say, no, Your Honor, it is not my wish that that motion be granted. And that's all you have to say. It's not your wish. That's it. Because your wish, being the sovereign, is the magistrate's command. Now, does it usually work out this smoothly? No, because the magistrates think that they're still sitting up there as chancellors or special administrators. Now, some of them, which I'll get into later, particularly that happened in Phil's case, I would say not some, I would say most of all of these attorneys slash judges, meaning that there's an attorney sitting up on there on the bench, who are all acting as special administrators slash chancellors. They all know what's going on. And I'll prove that through what happened in Phil's case when he served the status doc set on a presiding judge, or chief judge, who had been sitting on the bench for 35 years. And not only did that guy recuse himself, but like 2 weeks later, he took early retirement and he was gone, like done. I know what was running through his head. He was thinking, oh my God, if somebody knows this much about what the system is and puts us into this position, none of us are going to be safe. We're all going to get bankrupted. So he took early retirement. He left. I'll get into that later. So let's continue here. B, proceeding according to the course of the common law. Now, remember what it said about the origins of law in the Facts, Evidence, and Law document up here when it talks about when considered in relation to its origin. It is statute law or common law. Okay, if you only have two origins of law, and in the definition of a court of record, it clearly states that this court proceeds according to the course of the common law, that means no statutes. It doesn't have any statutes. You don't have to put in a statute, Roman civil law statute, or a rules, right? Like the rules of court, they put in their statutes about civil proceeding, right? Oh, I'm filing this motion based upon Rule 26B2. No, that's a barbarism at common law. I don't know what the hell you're talking about. I don't know what these stupid codes are. They have nothing to do with my court. What are you talking about? You're talking gibberish in my court. You're an idiot. Here's the thing. It works both ways, because when you're in front of a chancellor and you start talking about the common law, I've heard judges state flat out the Constitution doesn't have any weight in this court. What are you talking about the Constitution for? It doesn't have any bearing in this court. That it's irrelevant. And they're right, because it doesn't. It's all dealing with contract. And contract supersedes all the constitutions, because it specifically says in both state and federal constitution, all of them, that there shall be no law passed abrogating the right of contract. You're either in one side or you're on the other side as far as this is concerned. So you'd better be in the common law, and you'd better stay there, because the other side is nothing but Roman filth, and you will never, I shouldn't say you'd never succeed, because obviously my friend who does that quite well does succeed quite often, but that is far more effort than I want to put in to win a case. It's just, I don't have time to go through all that garbage and, if I miss a rule or don't do exactly this or that, that's what the Khazarian mob does. They set up all these impossible rules, and then they don't follow them anyway. Ever. And then they just submit everything to their 600-pound black-robed gorilla and says, here, you decide. You're the chancellor. Well, no, because in a court of record, the magistrate doesn't have any. On number C, its acts and judicial proceedings are enrolled or recorded for perpetual memory and testimony. That's usually what people think about a record. If you ask a judge, you say, is this a court of record? He'll say, well, it keeps a record. It's not what I asked, Your Honor. Is this court a court of record? Well, yes, I just said it keeps a record. Objection, Your Honor. You're not answering the question. Is this court a court of record? And then he'll finally have to acquiesce and say no. Or he might try it a third time and say, or he might get pissy with you and threaten you with contempt. I just answered that 2 times. You asked me one more time, I was going to hold you in contempt. No objection, Your Honor. You still haven't answered the question. And because you have the right to know the nature and cause of the accusations against you, which is also constitutional, he has to tell you whether it's a court of record or not. But there's no reason for you to get into that kind of argument with them ever, as long as you file your counterclaim, or countersuit, better put, into your court of record to force the inferior court system to prove to your superior court system that it has jurisdiction, which of course they can never do. Okay, so D, has power to fine and imprison for contempt. So what does that mean? It means when the magistrate wants to act like a moron and keep bringing in statutes, acts, ordinances, or codes, and or granting motions that you have specifically stated on the record that you do not wish to be granted, he is literally going against the tribunal of the court, and he or she can be held in contempt. Yes, you can hold a magistrate in contempt when they try to act like a judge or a chancellor or special administrator. You betcha, because that's exactly what needs to happen if we're ever going to order these people to do what they're supposed to be doing. Is threaten them with jail time. I've got the whole process for that because Bill Thornton took time, years ago to put all that together. And we've done that too. We've held judges in contempt. And of course, they don't do anything about it. But I am wondering, in certain aspect, how the sheriff's department does see it, because we held some judges in contempt and the judges kept moving forward and tried to issue a warrant for the arrest of the guy who had held them in contempt and defaulted them. And the sheriff's office won't act on that warrant. They basically refuse to act on that warrant. I think it's because they know what we're doing and they realize that they can't do anything about it and that they shouldn't, or else they'd be breaking the common law. And then E, finally, last one, E, is it generally possesses a seal. And that, of course, is the seal of your own house, which is another very important reason why the first thing you do when you do the status doc set is get your seal made, because that seal is going to be the seal of your court as well, not just the seal of your house. It stands for both things. And so that's a court of record. So what's a magistrate? All right, the word magistrate does not necessarily imply an officer exercising any judicial functions, and might very well be held to embrace notaries and commissioners of deeds. And then the importance of what a court of record is and its absolutism. No statutory or constitutional court, whether it be an appellate or Supreme Court, can second guess the judgment of a court of record. Now, that's not part of the holding. That's just basically a note that I put in there, so I should probably put it in purple. But I do add it when I do my law of the case. So this is where the holding starts. The judgment of a court of record whose jurisdiction is final is as conclusive on all the world as the judgment of this court would be. Now, this is the Supreme Court saying this. It is as conclusive on this court, meaning the Supreme Court, as it is on all other courts. It puts an end to inquiry concerning the fact by deciding it. Right. And how does that happen? Because there's nothing higher than the sovereign's law. And or if the defendant demanded a jury, there's nothing higher than a general verdict from a jury. Because in a general verdict, a jury decides both the facts and the law that applies. I'll get into general verdicts later when we talk about what happened with Drew's case. But for now, that's the importance of a court of record. The acts of a court of record are known by its records. Judicial records are not only necessary but indispensable to the administration of justice. The court judgments can be evidenced only by its records. The acts of a court of record are known by its records alone and cannot be established by parole testimony. The court speaks only through its records. The judge speaks only through the court. So what's a court? It's the record. What can the judge do? He can only see what's on the record. You can't deviate from it or anything else. So what you do is you set the record straight and make sure that your case is going in the direction that you want it to go for the right reasons. And once that happens, and you establish facts and establish various different law that applies, then there's nothing, but particularly if the jury is the one that's going to be determining the law, there's nothing that the magistrate can do at all to alter it. Okay, so what's an inferior court? Inferior courts of those jurisdiction is limited and special, and whose proceedings are not according to the course of the common law. All these courts out here, all these private for-profit courts, they're all inferior courts because they do not proceed according to the course of the common law. And it's something right out of the Illinois Constitution, of the 1818 Illinois Constitution, Article 2, Section 25. No judge of any court of law or equity. So you got courts of law and you got courts of equity. Two different kinds of court. Secretary of State, Attorney General, blah, blah, blah. Clerk of any court of record, sheriff or collector, blah, 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 shall have a seat in the General Assembly, nor shall any person holding an office of honor or profit under government of the United States hold any office of honor or profit under the authority of this state. This is basically separating the feds from the state. But in the 1818 Illinois Constitution, it says clerk of any court of record. If anybody questions that, go look up your original state constitution. And I'm not saying that it's going to be a guarantee that you're going to find the word court of record in every single constitution, but the vast majority of them have that term. So the terms equity and chancery, court of equity, and court of chancery are constantly used as synonyms in the United States. It is presumed that this custom arises from the circumstance that the equity jurisdiction, which is exercised by the courts of the various states, is assimilated to that possessed by the English courts of chancery. Indeed, in some of the states it is made identical therewith by statute, so far as conformable to our institutions, which is basically a sneaky way of saying we're going to run it like this, and so that it doesn't conflict with common law, but not tell you that it isn't common law, and that you have no rights in a court of equity or chancery. It's all what the judge wants to do with you. They can do whatever they want to, because you're just two infants that are throwing garbage at each other, and he's there to fix that problem. But once you establish your status, then you're not going to be seen or administered as one of those infants. So we had inferior court up here, and now we've got superior court. So to constitute a court as a superior court, as to any class of actions, within the common law meaning of that term, its jurisdiction of such action must be unconditional, so that the only thing requisite to enable the court to take cognizance of them is the acquisition of the jurisdiction of the persons of the parties. What does that mean? It means you served them, you process served them with a copy of the suit, which was recorded into the court clerk to be placed into the record. That's it. That gives you jurisdiction of the parties. There could be an issue from the standpoint that you might be trying to take jurisdiction in your court of record that should be filed in a different county or a different state, meaning the venue's wrong. If the venue's wrong, then yeah, they can still say, well, you don't have jurisdiction because you live in Colorado and the plaintiff or the defendant lives in New York, and everything that you're filing as far as your action at law is concerned, all those things happened in New York. It would be incorrect to file it in Colorado. So things like that. So as long as your venue is correct, you're good. That's a court of record. That's what the common law is. I covered the rest of that in the class, and you can buy that class, the ins and outs of court class, by a $75 donation to the VSOF PayPal, and then I'll give you all the links to that class. Okay, so the defendant has a right to a jury, always, and because he can protect himself from a crazy sovereign by demanding a jury of his peers, so basically fellow members of his sovereignty. And if the jury renders a general verdict on the matter, they judge both the law and the facts. And this will be covered down here in D below, which I'll get to in a second. So what's a jury of your peers? Okay, you must be a member of the peerage. That's one of the people. Now, a peer does not mean you're equal. I mean, that's not the definition of a peer. It's usually what people think it means, but it's not what it means. A fellow peer is a member of the peerage. A member of the peerage is a member of the sovereignty. They're equal from a standpoint that, yes, they're your fellow sovereign, but a member of the peerage has to be one of the people. So you cannot be a citizen of the United States. One of the stories that Bill Thornton tells on his website is about a court case which apparently there was a guy that demanded a jury of his peers from the judge, and he was the defendant in this particular scenario. I think it was for a traffic case. And so he made it very clear to the judge that he understood what a peer was. And every time that they kept bringing back, citizens of the United States and trying to put them up on the stand to be selected as a member of the jury, he'd say, objection, Your Honor, he's a citizen of the United States. No one would admit they weren't subject to the jurisdiction of Congress, basically. And so eventually they had to drop the case because the judge ordered the sheriff to go out and find some peers, and he had to report back they couldn't find any. Because no one would admit that they weren't a subject. They weren't subject to the jurisdiction of Congress, which I just find to be absolutely hilarious. And it makes sense. So it has solid footing in law, but even Bill himself says, he didn't follow up on the story of that court case and, lock down all the information. So it's one of these, kind of urban legend sort of things. But at the same time, it has solid foundation in law, so it makes sense that it would have gone down like that. Okay, so that's what a jury of peers has to be. All right, let's open up handout 7, which is the definition of verdict. There were some things in here that I actually had never looked at. I had never specifically looked up this term before, and I was thinking about the proof of life, proof of aging quest, and there's another document which I've now finished. What it is I figured from a standpoint of we having to get 12 people together to do the proof of life and proof of aging quest, that if you already have the petite jury together, why not have the petite jury also basically confirm your status and confirm the fact that yes, you're the executor of the estate. Yes, you're the sole lawful heir of the estate. Yes, you have the sole lawful claim to the estate. Yes, any trust that's created from any res of the estate belongs to you. Basically, a way of confirming. In short, it's basically properly suing out one's livery is really what the term is. And that was a process that used to be done through what was called the Court of Wards and Liveries. You can look up the Court of Wards and Liveries just on Wikipedia. I mean, as bad as Wikipedia is, it does have a pretty good entry for the Court of Wards and Liveries. What this court was the place where the heir had to go to sue their guardian in order to sue out their livery, to have livery. And livery is the root word of delivery, and of course de is French. It's a prefix for meaning of or from. You can see it used in names a lot of times too, like, Evelyn D. Rothschild. D is not some middle name. It just means of the house of Rothschild. So Evelyn of the house of Rothschild, Evelyn D. Rothschild. So D livery, to have